Hi everybody. Thank you to The Wire for inviting me here at their studio today to discuss some of the legal issues that are involved in the infamous Babri Masjid and Ram Janmabhoomi Ayodhya matter, and the matter is now before the Supreme Court. Before we do that, two disclaimers. The matter is right now sub judice, which means it's being argued before the Supreme Court. Therefore, we cannot comment on this case in any manner whatsoever. The purpose of this video is merely to spread legal information and awareness about some of the issues involved in this case and to present the information for larger people to understand and appreciate. Secondly, myself, I'm attached with the case, and therefore everything I say should be heard in a subjective manner and should be considered merely as my personal opinion. Now, if we ask common people, this is a case that has sort of taken the consciousness and has attracted a wide public debate in our country right from the very time that the High Court impugned judgment was delivered on September 10, 2010. The High Court judgment was a three-judge bench judgment which was given by a bench of Justice Sudhir Agrawal, Justice S.U. Khan and Justice D.V. Sharma. After the judgment came out, there was an uproar in the country as all the parties seemed to some extent dissatisfied with the matter, and of course there was an appeal made to the Supreme Court. The Supreme Court stayed the matter since 2011 and now is being argued on a continuous basis from 8th February 2018. There has been a request that given the seriousness of this matter, it should be heard on a daily basis, but so far that hasn't happened. At the moment, the matter is being listed, let's say 1 in 2 weeks, and the last it was listed was on last Friday, 27th of April 2018. Now, what is the matter and what is the entire dispute about? People do know that the contention is what happened on 6th December 1992 when allegedly a group of car sevaks from RSS, BJP and the Vishwa Hindu Parishad brought down the Babri Masjid. Both the sides, the Hindu side and the Muslim side, it's wrong to say and divide the sides like that, but only for our common understanding, there are two versions of the Hindu side and the Muslim side present and have been contesting upon. According to the Muslim side, the story goes back as long as 1528 when Mir Baqi, under the instructions of the Mughal Emperor Babur, constructed the Babri Masjid. According to them, they have been in possession of the Babri Masjid since then, and there have been communal tensions in 1855, 1949, but overall it was them who have been in possession at least since till the year 1949. From 1949, the entire dispute, who does the land belong to, there was a placing of an idol by a few people, allegedly from the Hindu side, who put the statue or an idol of Lord Ram inside the Babri Masjid in the central dome. And since then, there has been a huge dispute about who has a right and who can worship at the disputed property. Now, according to the so-called Hindu side, the story goes back perhaps allegedly as far as 7 lakh years back or 9 lakh years back. There is also a dispute on that, when Lord Rama was born. And according to their side, Lord Rama was born at this exact spot where Babri Masjid stood. And they think or they allege that there was a Hindu temple of Lord Rama at the very site, which was brought down by the Muslims, and Babri Masjid was built on that place. Now, the question is, was there a Ram temple at the place of the Babri Masjid? But another argument or another question, of course, of importance is that irrespective of what existed there before, what happened on 6th December 1992, was it right, and what should happen as far as the criminal case is concerned? Now, it's important to highlight here that in April 2017, the Supreme Court asked to reopen criminal charges and criminal inquiry into some of the top leaders of the BJP, including Mr. L.K. Advani. But this case, which is now before the Supreme Court, we call it M. Siddique versus Suresh Das and others. And for those of you who want to follow up the case, all you need to do is go to the Supreme Court site, put in either the name of the parties or the number. The number of the case is, it's a civil appeal. So it's a civil appeal number 10866 or 10867 of 2010. So the civil appeal that's being heard before the court has nothing to do with the criminal charges. It is specifically challenging the impugned judgment given by a 3-judge bench of the Allahabad High Court, the Lucknow bench, on September 10, 2010. As per this impugned judgment, it's a judgment of around 5,000 pages. The High Court gave a verdict whereby it decided to divide the disputed property in Ayodhya at the Babri Masjid site in 3 different fragments. it said that the one-third site or the one-third of the property would go to the Muslims or the Sunni Waqf Board, UP Sunni Waqf Board. One-third of it would go to Nirmohi Akhada, and people should know that Nirmohi Akhada is also considered to be a part of a Hindu denomination, and the remaining one-third would go to the Hindus or the two parties before the court, Ram Lalla, that is the deity himself, and the holy land of Ayodhya. Now, just to take a step back and explain this a little bit more, the High Court was hearing a total of 4 suits. Originally, there were 5 suits. The first suit was filed in the year 1949 by one Mr. Gopal Visharad. The second suit who asked the court that he has a right to pray the infant or the idol that's been placed in the central dome of the Babri Masjid. The second suit was filed by one Mr. Paramhans Raghubar Das. The third suit was filed by Nirmohi Akhada. Nirmohi Akhada has claimed that a certain part of the interiors of the Babri Masjid, a disputed site, belongs to them. There was a chabutra, then they said there is Sita ki Rasoi, and there are some lands that they have claimed. That's how they get interested in the matter. The fourth suit was filed by the UP Sunni Waqf Board. According to the Sunni Waqf Act that was enacted in Uttar Pradesh, the property is now considered to be a Waqf property of the UP Sunni Waqf Board under the Sunni Waqf Act. So that's how the Muslim side get involved. And finally, there was a fifth suit by Ram Lalla and the Ayodhya Bhumi. Of course, it's also in question as to whether they have juristic personality. According to a long tradition of case laws, it can be said that the infant or Lord Ram can himself be a party, but it is contested before the court. So this is how we had 5 suits, and in the run-up to the High Court judgment, one suit was dropped, and the High Court was listening to these 4 suits altogether. It's also important to bring another nuance forward, which is important in this case. Usually, because it was a title dispute, it was a matter that pertained to who does the land belong to. It was originally being heard by the additional district judge and the civil judge of Faizabad. But as per a division bench judgment of the High Court, given the seriousness of this matter and based on the applications filed by the UP government itself, they passed an order saying that the matter should be withdrawn from the additional civil judge and the district judge of Faizabad, and the High Court is going to hear the witnesses, look at the evidence and deliver a judgment. They also requested the Chief Justice of the High Court to nominate a third judge so that a full bench, a 3-judge bench of the High Court can deliver the judgment. So when the impugned judgment was delivered and now it is being in appeal, it's only being heard by the Supreme Court by way of a first appeal as opposed to a regular second appeal. Now, coming back to the impugned judgment of the High Court, the verdict, as I said, simply said that the land should be divided, the disputed property should be divided between the Hindus, the Muslims and the Nirmohi Akhadas. This was appealed by the UP Sunni Waqf Board and later by the other parties before the Supreme Court. And now as the Supreme Court begins hearing on this matter, it's been already listed for 4 different days. As the Supreme Court begins hearing on this matter, there are different issues that the Supreme Court has to hear. The matter right now is before a 3-judge bench led by Honorable Chief Justice Justice Deepak Mishra along with Justice Abdul Nazir and Justice Ashok Bhushan. The various issues before the court that the court will have to see in times to come is pertaining to limitation, it's pertaining to specific relief, juristic personality and the title over the property. Whether and who has a better title to the property. They have both claimed their title through adverse possession. Adverse possession simply means when a party is in continuous and hostile possession of a particular property, they can be said to be in adverse possession. Was there adverse possession, or did the Muslims have a better title, the Hindus had a better title? These are all issues they will unravel before the court in times to come. But for now, the controversy that the Supreme Court is witnessing is regarding one particular question. And that question is, who should hear this matter before the Supreme Court? Should it be a 3-judge bench as it's the matter now? Or, given the importance of this case, should the matter be referred to a larger 5-judge bench? Now, senior advocate Rajiv Dhawan, appearing for the Muslim side, has been arguing in favor of referring this matter to a larger 5-judge bench. On the last date, which was 27th of April, due to not keeping well, he was not present in court. But before that, on the last two occasions, he's been arguing on the very important case called the Ismail Faruqi judgment, which was a 5-judge bench delivered by the Supreme Court in the year 1994. Just to unravel the mystery and demystify the law on the Ismail Faruqi judgment, let's really understand what happened in this case. Ismail Faruqi was a judgment whereby the Supreme Court said that it made several observations, but it also said that Babri Masjid cannot be considered to form an essential part of the Islamic religion. In other words, it was saying that Muslims could pray anywhere and the Babri Masjid cannot be given any special status. In the Ismail Faruqi judgment, the Supreme Court was also hearing a presidential reference made by President of India, then President of India, Mr. Shankar Dayal Sharma, who, exercising his powers under Article 143, subclause 1 of the Indian Constitution, asked the Supreme Court to give an opinion on whether there existed a Hindu temple at the disputed site. While the Supreme Court in the Ismail Faruqi judgment refused to make any comments on the presidential question, they did make their observations on the legal validity of an act passed by the government, which is called the Acquisition of Certain Area at Ayodhya Act 1993, which sought to acquire not only the exact Babri Masjid disputed site, but even areas surrounding it to build a temple, a mosque, a library and a museum. The court said that there should not be any permanent construction, but allowed the government to acquire the land. However, the Supreme Court also said that one particular provision in the Act, which said that all the proceedings pertaining to the matter would come to a rest, was held to be invalid and was severed from the Act, because the court said that would practically mean taking away the rights from people such that they will not be able to take it to the courts of law. So the position in the Ismail Faruqi judgment was that they did not answer the presidential reference case. They said the Acquisition Act is valid, but Section 4, subsection 3, which says that all the proceedings relating to the case should be considered to have come to a halt, was considered to be invalid. But the observations made in the Ismail Faruqi judgment on essential practice of religion is what Senior Advocate Rajiv Dhawan says is problematic. According to Senior Advocate Rajiv Dhawan, these findings also permeated the impugned judgment of the Allahabad High Court, wherein it made several observations. Now, since Ismail Faruqi judgment was a 5-judge bench, Senior Advocate Rajiv Dhawan is arguing before the court that this matter should be heard only by a 5-judge bench. On the last date, in the absence of Senior Advocate Rajiv Dhawan, Senior Advocate Raju Ramachandran also appeared from the Muslim side and made his submissions that given the constitutional ethos involved in this case, questions of secularism, rule of law and democracy, this matter should be heard by a 5-judge bench. He drew attention on the white paper that was released by the government of India in 1993 on Ayodhya. He also made reference to the white paper that was released by BJP and several other judgments which have made pertinent observations on when a matter should be referred to a 5-judge bench. He also said that given that polygamy matter was decided by a 5-judge bench, this case definitely warrants hearing by a larger bench. In response, Senior Advocate Hari Salve, along with Senior Advocate K. Parasaran and Senior Advocate S.K. Jain, made arguments on behalf of the Hindu side, claiming in a sense that this matter should be seen only as a title suit, as a property dispute, and therefore it is perfectly alright for a 3-judge bench of the Supreme Court to hear the matter. Senior Advocate Hari Salve made the submissions that we have come a long way away from the year 1992 and all political sensibilities and religious sentiments should be kept away at the door of the court, and this matter should be seen for what it is, which is a property dispute. He also said that a property dispute and to appreciate the evidence and witnesses, a 3-judge bench would suffice. Senior Advocate K. Parasaran, taking this argument forward, said that in a civil matter where there are no statutory wires involved, which is we are not challenging the constitutional validity of a statute, it is perfectly all right for a 3-judge bench to hear this matter. Senior Advocate S.K. Jain further made submissions that it is a discretion of the court whether or not to refer the matter to a larger bench and also at what stage to refer it. So now the entire attention of the Supreme Court is to decide whether this matter warrants reference to a larger bench, And on the next date of hearing, which is 15th of May at 2 p.m., hopefully Senior Advocate Rajiv Dhawan would be making attempts to satisfy the court as to why this matter should be referred to a larger bench. Now, this is a matter which will be unraveling as we move forward, but it is my request to you that we all keep out an eye and try to understand the legal issues involved in the matter, except just sort of appreciating the political ramifications of the matter. Keep out an eye for this matter, and we will discuss it as the matter unravels. Thank you for watching.